Our next speaker is Robert Garbini. Good afternoon, and after that will be Margaret McCann.
Thank you. Madam Chairman, members of the board, I want to thank you for allowing me to speak. My name is Robert Garbini. I'm the president of the National Ready-Mix Concrete Association. Founded in 1930, NRMCA represents 1,300 member companies and their subsidiaries that employ more than 125,000 American workers, of which many are unionized. The association represents companies that operate in every congressional district in the United States. The industry is currently estimated to include more than 65,000 concrete mixer trucks. NRMCA represents a unique industry which relies on numerous employees located at many different production plants in order to provide a perishable product for a just-in-time basis on all hours of the day. Currently, the vast majority of the ready-mix concrete industry is made up of small businesses. As with most small businesses, owning and operating a ready-mix concrete company means that you're responsible for everything, whether it's ordering inventory, hiring employees, meeting environmental and safety regulations, dealing with an array of government mandates, and when appropriate, even educating employees about union organizing decisions and their labor rights. Due to the unique features of the ready-mix concrete industry, such as isolated plant locations, unpredictable delivery hours, dispersed employees, and unusual business hours, it is the opinion of NRMCA and its members that the NLRB's proposed rule will not allow companies ample time to accurately and thoroughly assess the process, actions, and options associated with a union election, or to educate employees to make an informed decision. Contrary to the intent of the proposed rule, we believe that the proposed time frame will lead to a longer union election process. Many ready-mix concrete companies do not employ in-house counsels or experts knowledgeable about labor laws. As such, many of these same companies are located in rural areas, and thus legal counsel specializing in union organizing drives is not readily accessible. This very real scenario will lead to a greater number of pre- and post-election complaints and possibly unfair labor practices due to objectionable actions on the part of the employers who are unfamiliar with the intricate and confusing laws and rules governing union elections. Furthermore, we believe that the proposed rule restricts employees' ability to hear from their employer on issues that involve and affect employees, employer, and union alike. This amounts to a grave disservice to employees' capacity to make an educated decision about their employment future. The ability of unions to hear from both union and employers about creating a collective bargaining relationship should be the foundation of any proposed rule to be built upon. As mentioned, many ready-mix concrete companies are already unionized. It is their experience that a trustworthy, honest, and accountable and open cohesion between union, employee, and employer is necessary for all parties to prosper and to maintain a productive working relationship. NRMCA believes that this proposed rule does not adhere to these principles. Also mentioned before, concrete companies have many employees that work at various hours at numerous concrete plants. The current rule, although not perfect, provides the flexibility for the concrete companies to reach out to each individual plant and the entire employee base in order to thoroughly inform them about a collective bargaining relationship, their rights, and the proposed roles of the union and employer should they choose to organize. NRMCA believes that the proposed rule will not allow companies ample time to hire legal counsel, accurately identify all the issues needing consideration, draft a statement of position, determine employee categories, prepare an accurate preliminary voter list, discover relevant evidence, and thoroughly educate the employees about creating a collective bargaining relationship. The flexibility in the current system allows companies to accurately and thoroughly assess the process, actions, and options associated with the union election, as well as to adequately educate employees and thus should be kept intact. NRMCA supports employees' rights to make informed decisions about their employment future. We also believe in protecting an employer's opportunity to be part of that process. Creating a collective bargaining relationship should not be a closed process or a snap decision. NRMCA encourages and urges the NLRB to refrain from issuing a final rule on these proposed changes. Thank you for allowing me to speak. Happy to answer any questions.
Thank you for being here. Some questions? This gentleman didn't even use up his whole 5 minutes, so, oh, there
Just in time.
You still have a minute. Anything more you want to add?
I've got one question, just
Sure.
in terms of the folks who you work with and what would be helpful to them in the process that you described. One of the things which hasn't been discussed today is in the proposed revisions that if they were to be adopted, the petitioner would be obligated to serve immediately on the employer, followed up by the region serving as well, a written description of the process, accompanied by a written, essentially, narrative of what the employer will have to do if it so wishes at the hearing. I guess my question is, will that be helpful in the preparation, in your view, or what would be? That is, if we were attempting to make it more transparent what the process consists of for people who may have had no experience previously, and to specify exactly this is what's going to happen, and here are the choices you're going to have to make, and here's what you're going to have to do when the hearing opens. Will that be helpful, and what would be helpful?
Well, to answer your question, Board Member Becker, I think that would be helpful. Certainly, it would be helpful, especially when a lot of these ready-mix companies are one-plant operations. They might include no more than 15 or 20 employees. Many of them they're family-owned companies. They've never probably had experience with a unionization or petition that goes on. I think the problem is going to come in with the length of time or the amount of time, though. I think that's an excellent suggestion, but I still think there's going to be some necessary time for them to prepare. They're not going to have the experience to be able to go out and say, oh, I know exactly who to call. What do these terms mean and everything else? So that's why at this point in time we're urging that we just remain with the current rule.
Let me ask you a question.
Sure.
Based on your experience in this industry. A lot of the comments this morning have been about how these proposed rules would curtail an employer's ability to campaign with its employees and inform its employees of its point of view. Is there some kind of general practice that employers in your group do in terms of campaigning?
I can't say with any certainty that there's very specific things that go on. I know a lot of the the companies that are familiar with the union process and so forth. They want to make sure that their employees, first and foremost, are taken care of, whether it's in the salary area and benefits and so forth. So a lot of those things, I think, I can't say categorically that they act in this particular fashion, but I do know that a lot of them are very, very caring about their employees and try to ensure proper compensation. And if that's, I don't consider that to be trying to of any move to try and prevent unionization. They're trying to say we're providing a very good standard of living for you, and that's our offer to you. So, but in any kind of other capacity, I couldn't address that. Yeah.
Anything else? Well, thank you.
Do you have any idea what percentage of your industry is unionized?
I think it's about 12%.
Thank you.
Thank you.
Thank you.
Garbini, thank you for being with us today. Appreciate your comments.